I am Dr. Devaruti Haldar, and in this session, I am going to discuss about jurisdiction on cyberspace. Let us now understand about jurisdiction, especially related to cyberspace. Jurisdiction means court's power to hear a case, give orders to the parties, create precedents, and prescribe punishments. Let us now understand about types of jurisdiction. It can be subject matter wise, that is, subject matter of jurisdiction, which can be civil or criminal, that is, a court can take up either a civil matter or a criminal matter. Personal jurisdiction, that is, against a person or territorial jurisdiction, and pecuniary jurisdiction, which is related to amount of claim. We will now understand about the prerequisites of jurisdiction and the theories. As we have seen in the previous slides, jurisdiction can be jurisdiction to prescribe, which is prescriptive jurisdiction, jurisdiction to adjudge, and jurisdiction to enforce. The theories and principles of jurisdiction can include subjective territoriality, objective territoriality, nationality principles, protective principles, passive nationality principles, and universality principles. Us about the principles of jurisdiction. Subjective territoriality. Here, act or conduct is committed within a forum state. The offender can be a resident or a non-resident of the forum state. The forum state has right to prescribe laws for violating social legal norms. Objective territoriality. Here, the act or conduct is committed in other country. Effect is felt in another country, which is not the country where act or conduct is committed. The country where the effect is felt can prescribe laws. This also includes effect test. Nationality principle. Here, the act or conduct is committed in the forum state. The offender is a national of the forum state. The forum state can prescribe laws. It can be an active nationality or it can be a case from passive nationality. That means where it is the nationality of the complainant. Section 1 of the Information Technology Act 2000, amended in 2008, can be considered as a good example of this particular principle because it is prescriptive in nature and it also discusses about jurisdiction. Protective principles. Here, this speaks about securing national interest, integrity, etc. in foreign state. For example, if terrorism happens or hacking happens targeting a particular country, that victimized country can exercise jurisdiction over the offender. Passive nationality. Here, the forum state takes up complaint of complainant. The state extends jurisdiction to its national who has been victimized and who is the complainant. Universality principle speaks about the forum state which takes up matter for universal interest. Here, the conduct is universally accepted as illegal. For example, child porn or cyber terrorism. These are the conducts which are universally accepted as illegal under the EU Convention on Cybercrimes. Now comes the most important issue, that is, conflict of laws for jurisdiction on cyberspace. The questions which can come up in this regard are where it was committed, where the effect was felt, the offender belongs to which country. The main issues related to conflict of laws for jurisdiction on cyberspace may include questions such as which country can adjudicate? Are offences committed online are extraditable? How to enforce the orders? What happens when the offences are committed by individual persons targeting another person or targeting a state or corporate house? What happens in cases of website liability? Which state can exercise jurisdiction in such cases? Questions regarding treaties, procedure prescribed as per the domestic procedural laws. The tangle of jurisdiction on cyberspace could be understood from the example of Playboy Enterprise Inc. versus Chuckleberry Publishing Inc. Here, the defendant operated website from Italy. The website is made accessible to users in US on the basis of subscribership. The defendant here displays obscene photographs on website. Defendant distributes such photographs to subscribers who are also residing in US. Petitioner brings the case in the US court. Point to be noted here is that the defendant operated the website from Italy. The court held that the defendant violated prohibitory injunction for distribution of such pictures in the US. The court ordered curtailment of access to the website in the US. However, outside the US, the website was accessible, which means that the website was actually blocked in the US, but otherwise the website was still accessible in non-US countries. Now, how to resolve the issue of conflict of jurisdiction, especially for cases that happen or may occur involving cyberspace? This can be read from three approaches: US approach, European approach, and for the Indian purpose, it can be also studied from Indian approach. We will now understand about the conflict of jurisdiction issue from the US approach. For this, we must understand about long arm statute principle. According to long arm statute, it allows the local court to obtain personal jurisdiction over out-of-state defendants. The defendant must have sufficient contact with the forum state. This contact can be minimum contact. In the case of International Shoe Company versus Washington, which is a 1945 case, it was held that two conditions must be fulfilled for getting the minimum contact, that is, continuous activity within the forum state and cause of action should arise out of that activity. This was also followed in CompuServe Inc. versus Patterson in 1996. Depending upon the long arm statute principle, and also after understanding the long arm statute principle, we should now understand about general jurisdiction principles. It says that out-of-state defendant has such substantial contacts with the forum state that personal jurisdiction will be invoked. In such case, the cause of action may not be related to the out-of-state defendant's contacts with the forum state, but the out-of-state defendant must have such substantial contacts with the forum state that the personal jurisdiction shall be invoked. From the understanding of general jurisdiction, now we will understand about specific general or specific personal jurisdiction. According to this understanding, the defendant's cause of action should be related to the forum state. The defendant ought to have purposefully availed himself of the privileges of doing business in the forum state. This was understood and decided in Burger King versus Ruswick, which the court also held the cause of action should have arisen from the defendant's activities within the forum state, which is not his own state, and the jurisdiction should be exercised in a fair manner. In case of specific personal jurisdiction, the US courts also applied sliding scale approach. This was first taken up in Zippo Manufacturing Company versus Zippo.com in 1997. In such cases, two things must be considered. One, the defendant simply posts some information which is accessible to users in other jurisdiction. Second, the defendant enters into contract with residents of foreign jurisdiction and knowingly there is a repeated transmission of computer files. It was held that principles of personal jurisdiction applies. CompuServe Inc. versus Patterson also followed the same approach. To understand the sliding scale approach, we must also understand about the nature of website. There are three tests on the basis of nature of website to understand the sliding scale approach. The first is passive website test. In such cases, the websites are specifically maintained for uploading some information. It may not have more interaction. It may or may not attract long-arm statute jurisprudence. This understanding was taken up in Ben Susan Restaurant Corp. Versus King. Next is interactive website. Here, the website is more than a mere passive website. The website may share information, may provide platform for interaction. The information reaches out to different locations and jurisdictions. It necessarily attracts personal jurisdiction, including specific personal jurisdiction and long-arm jurisdiction. The next is interactive mixed website. Here, the interaction is to a lesser degree. Such websites are maintained for soliciting or advertising business. It may attract personal jurisdiction and long-arm jurisprudence. Post Zippo, from 1999 onwards, the US courts are also looking at effect test. Here, the website maintained or registered can be in different jurisdictions. The website used for uploading content that may be accessible in other states. It may contain interpersonal crimes, defamation, uploading privacy infringing contents, etc. The acts are actually tortious acts expressly aimed at forum state and causes harm to the plaintiff who is residing or who is staying in a state where the act or conduct has not been committed. That means the effect is felt in a different place. That means act done somewhere and effect is felt elsewhere. This was taken up in Blackie versus Continental Airlines Inc. in 1998. Further, questions of conflict of jurisdiction may also arise in cases of click wrap, browse wrap, or shrink wrap contracts. Here comes the question of choice of law and forum selection. Mostly in click wrap, browse wrap, or shrink wrap contracts, the parties may enter into agreement or contract through I agree button. In this case, the jurisdiction of a specific place where the website is hosted or registered may play a dominant role. In such cases, due diligence also plays a significant role. For example, Section 79 of the Information Technology Act 2000, amended in 2008, speaks about this due diligence for the websites. Now, let us understand about the European approach. There are two regulation and convention which may help us to understand about European approach. The first is Brussels Regulation 2002 on jurisdiction, recognition and enforcement of judgment in civil and commercial matters. It says, persons domiciled in a contracting state shall be sued in the courts of that state irrespective of their nationality. It also says, consumer has a right to take action against trader or website in his or her home court. Further, it also says, irrespective of the nationality of the defendant, the order of the court of the plaintiff would be enforceable against the defendant. The next is Rome Convention 1980 on the law applicable to contractual obligations. It says, a contract shall be governed by the law chosen by the parties. It should be expressed and demonstrated clearly. In case such choice of law is not indicated by the parties, the contract shall be governed by the law of the country with which it is most closely connected. Explanation of the term most closely connected says the country or state in which the party who is to effect the performance which is characteristic of the contract has at the time of conclusion of the contract his habitual residence, or in the case of a body corporate or unincorporate, its central administration. A choice of law made by the parties shall not deprive the consumer of the protection afforded to him by the mandatory rules of the law of the country in which he has his habitual residence, if in that country the conclusion of the contract was preceded by a specific invitation addressed to him or by advertising, and he had taken in that country all the steps necessary on his part for the conclusion of the contract. Now, let us understand about the Indian approach. The Indian approach relies more on the US approach. The Information Technology Act 2000, amended in 2008, has prescriptive jurisdiction under Section 10. It also follows the universality principles, especially where it prescribes rules, regulations, etc. and laws for punishment for cyber terrorism, child pornography, etc. This section clearly mentions that Information Technology Act shall extend to the whole of India and also to the offences committed outside India by any person. This means that this law has intra-territorial and extraterritorial jurisdiction for any offence under this Act. Section 1 therefore extends its scope to offences committed by any person even when it is committed abroad. Section 1 can be read with Section 75 of the Information Technology Act. India also follows the long arm statute rule and specific personal jurisdiction to a certain extent. India also follows effect test principles. Section 75 extends the scope of the Act to apply for offence or contravention committed outside India. Section 75(1) says that the Act applies for offences committed outside India by any person irrespective of his nationality. It also states that the Act shall apply to an offence or contravention committed outside India by any person if the act or conduct constituting the offence or contravention involves a computer, computer system, or computer network located in India. India also has adopted the sliding scale approach, and this has been seen in India TV Independent News Service Private Limited versus India Broadcasting Live LLC, which is a 2007 case, which considered the nature of the website. India also goes for effect test. This was seen in the case of Registrar Judicial Madurai Bench of Madras High Court, Madurai versus the Secretary to the Government Union Ministry of Communications, Government of India, New India and others, suo motu WP writ petition of 2017. This is the case of Blue Whale. Now, let us understand about the grey area. India is not signatory to EU Convention of Cybercrimes 2001. There is also no treaty for extraditing criminals for online offences, which are recognized under the Information Technology Act 2000, amended in 2008. Thank you.